Ms. Corcoran.
Mr. Chief Justice, and may it please the Court, Robinson v. California holds that status-based punishment schemes are categorically cruel and unusual under the Eighth Amendment. The challenged ordinances inflict status-based punishment in both effect and purpose. Although the city describes its ordinances as punishing camping on public property, it defines campsite as any place a homeless person is while covered with a blanket. The city interprets and applies the ordinances to permit non-homeless people to rest on blankets in public parks, while a homeless person who does the same thing breaks the law. The ordinances, by design, make it physically impossible for homeless people to live in Grants Pass without facing endless fines and jail time. The only question under Robinson is whether there's any meaningful difference between a law that says being homeless is punishable and a law that says being homeless while breathing or sleeping or blinking is punishable. In other words, does adding a universal human attribute to the definition of the offense make the punishment conduct-based instead of status-based? The answer is no. The purpose and effect of the second statute is exactly the same as the first, to make people with the status endlessly and unavoidably punishable if they don't leave Grants Pass. Indeed, all the ordinances do is turn the city's homelessness problem into someone else's problem by forcing its homeless residents into other jurisdictions. The injunction below leaves the city with an abundance of tools to address homelessness. It can impose time, place, manner restrictions on when and where homeless people sleep. It can ban tents and clear encampments. It can enforce the sleeping ban against homeless people who decline shelter. And it can fully enforce its laws prohibiting littering, public urination and defecation, drug use, and violent or harassing behavior. The only tool the city wants that it doesn't have is authority to impose a 24/7 citywide sleeping ban that forces its homeless residents to either move to another jurisdiction or face endless punishment. The state police power is broad, but it does not include the power to push the burdens of social problems like poverty onto other communities, or the power to satisfy public demand by compromising individual constitutional rights. I welcome the Court's questions.
In Robinson, there was a statute that outlawed, that said that to be addicted is a crime. Is there an ordinance here that says to be homeless is a crime?
So the language for the purposes of a temporary place to live bakes homelessness into the definition of the offense. Justice Sotomayor was talking about that earlier. So when you combine that language with the rest of the camping definition, what you have is an ordinance that says being homeless while sleeping with a blanket is punishable. And as I just said earlier, the question becomes, when you attach the status to the universal attribute of sleeping, does it then transform the offense into a conduct-based punishment instead of status-based punishment? I think the answer is no.